subject is malicious prosecution. My name is K. Umesh Rao. We are dealing with essentials of malicious prosecution. Before going to malicious prosecution, we must know what is the importance of prosecution. Every person has the freedom in bringing the criminal to justice. What is the care he has to take? But he should refrain from making false accusations against the persons. If we do that, it is called malicious prosecution. So prosecution initiated mainly because of hatred against some person is called malicious prosecution. It is the abuse of the process of the court. How? By wrongfully setting the law in motion on a criminal charge, thereby causing damage to the plaintiff. Damage to the plaintiff may be in person or his reputation. So malicious prosecution is a prosecution on a charge of crime which is willful, wanton, reckless against the plaintiff. It is the proceedings instituted from malicious spirit. It is ill-intended prosecution. It is abuse of the legal procedure. So prosecution has been initiated by the defendant against the plaintiff. Now, essentials of malicious prosecution. In order to constitute malicious prosecution, the following points are very essential. Prosecution, the proceedings or case instituted by the defendant against the plaintiff. Case was instituted without any reasonable cause. The defendant instituted the case willfully to gain some advantage to him. Such prosecution was terminated in favor of the plaintiff. Plaintiff sustained damage as a result of criminal prosecution. So malicious prosecution concerns with criminal proceedings only, but in civil it is called as malicious prosecution, civil proceedings. So now we will take up one case, Kedarnath versus Jacob Chandra. In this case, defendant lodged a complaint against the plaintiff, stating that plaintiff wrongfully took bullock cart belonging to the defendant and requested to take action. In this case, plaintiff was not arrested and not prosecuted. Defendant merely brought the matter before the executive authority. His action, whether it does amount to malicious prosecution, his action does not amount to prosecution, and action for malicious prosecution is not maintainable. Now, essentials of malicious prosecution. Here, prosecution should be done by the defendant. This is the first point. If the defendant must have been initiated the proceedings against the plaintiff, because the prosecution initiated by the defendant and damage is caused to the plaintiff. For example, defamation case, complaint is made by the defendant against the plaintiff. Plaintiff must prove pecuniary damage or financial loss has been caused. Mere presentation of complaint to the magistrate is not sufficient ground. Plaintiff must prove that damage actually resulted. Now we will study one case law, Gaya Prasad versus Bhagat Singh. In this case, defendant filed a complaint against the plaintiff before police. He made a complaint in the police station. Defendant supplied false evidences to the police. Based on the false evidences, police filed a criminal case against the plaintiff. He was arrested, remanded, and afterwards released on bail. Magistrate, after observing the case, dismissed the case after enquiry. Plaintiff was acquitted from the charges. Now, plaintiff brought an action against the defendant claiming damages for malicious prosecution. The trial court held that it is malicious prosecution and awarded damages to the plaintiff. The defendants appealed to the judicial authority of oath. He contested that criminal case was not instituted by me. Criminal case was instituted by the police and they have tried the case. And defendants are not complainants. The Judicial Commission dismissed the case in favor of the defendant. Now, what Judicial Council told? If the police decided to act on the information given by a private individual without a formal complaint, Crown becomes a prosecutor and not the individuals. The plaintiff then what happened? He appealed to the Privy Council. The Privy Council reversed the Judicial Commission's decision and confirmed the decision of the lower court. What Privy Council told? Police have special powers. Here, what is the important is the conduct of the complainant, conduct of the defendant before and after the complaint has to decide whether he is the real prosecutor or not. Second essential to constitute a malicious prosecution is termination of prosecution in plaintiff's favor. Plaintiff must prove that prosecution ended in his favor. If the prosecution is pending or not terminated in his favor, plaintiff has no right to sue. What is the meaning of termination? It is termination may be on the following grounds: acquittal on merits based on innocence or dismissal of complaint for technical defects. If plaintiff convicted, he has no right to sue. He cannot plead his innocence. In such cases, what is the alternative? In such cases, only remedy is making an appeal against the conviction. If the appeal is decided in his favor, then he can sue the defendant for malicious prosecution. Now, absence of the reasonable and probable cause. This is one more ground. Reasonable and probable cause is honest belief in the guilt of the accused based on all full conviction founded upon reasonable grounds of existence of particular circumstances. Shailaja Kaur versus Lallu. An illiterate villager has filed a suit concerning some land and engaged an advocate for that purpose. In the later litigation, in a different case, relating to the same matter or connected matter, the same advocate appeared against the villager. In the first case, he appeared in favor of the villager. In the second case, he appeared against the villager. The villager filed a complaint to the bar council against the advocate for professional misconduct. The bar council found the similarity of the land dispute. Ultimately, the bar council came to the conclusion that there were two different lands and gave the benefit of doubt to the advocate. Then, advocate sued the villager for malicious prosecution. The High Court dismissed the suit and held that there was reasonable and probable cause for the complaint made by the villager before the bar council. Therefore, suit was not motivated by malice. Another case, Abrath versus Northeastern Railway Company. Mr. Abrath had recovered large sum of money as compensation from the Railway Authority. This is towards the personal injury in respect of railway collision. Subsequently, Railway Authority has got some information that the injuries of M were not caused by the collision but artificially manufactured by Mr. Abrath, a doctor. The Railway Authority has made enquiries with legal advice and prosecuted Abrath for conspiracy, but he was acquitted. The action was brought for malicious prosecution against the railway. The Railway Authority held that defendants were not liable. Now, another point is malicious intention, that is very important. Prosecution instituted with malicious intention. Motive is not to bring the offender to justice. Motive is ill will. And defendant wanted to injure the party because of anger and revenge. We will take one case law. Srimati Sonarani Datta versus Debharta Datta. Defendant filed a false FIR against a plaintiff. He made a complaint to the police officer stating that plaintiff and his sister snatched her 1 earring and she sustained bleeding injury. Inquiry found that offense is theft and assault. So defendant clearly knows that plaintiff has not snatched the earring. Complaint was lodged with, it is out of malice. Another is damages. Here he has to prove that the plaintiff has to suffer the damages as a result of prosecution complaint. Even though the prosecution is submitted in favor of the plaintiff, he have to show that he has suffered damage as a result of prosecution. It may be claimed damages for reputation or damages for person or damages to property. We will take case law. Kama Prasad versus National Buildings Constructions Corporations Private Limited. National Corporation found that some article was missing while preparing inventory. They checked it with the stock registers. Plaintiff Kama Prasad was in charge of the work. Kama Prasad was prosecuted, but he was given the benefit of doubt and acquitted. Plaintiff brought an action for malicious prosecution. It was held that there was no malice because plaintiffs could not prove that he had been harassed by the officers. Another case is Girija Prasad versus Umashankar Patak. Plaintiff was a practicing advocate in Madhya Pradesh. He was a Janasangh leader. He started an agitation on question of food scarcity and gone to hunger strike with his followers. Girija Prasad was sub-inspector deputed outside the collectorate to control the crowd who support the agitation. Then there was some bullet shots made from the revolver of sub-inspector. Girija Prasad has lodged an FIR against the advocate, stating that he was assaulted by some person and the plaintiff Umashankar Patak was present at the scene and was insisting the crowd against him. The case was investigated and the plaintiff was arrested and finally acquitted. The plaintiff sued the police officer for malicious prosecution. High Court of Madhya Pradesh found that the report prepared by the Girija Prasad was false and at the relevant time the plaintiff was not present there but he was appearing in front of the civil judge Justice Verma. It is held he is liable for malicious prosecution. Thank you.